Good day to you and welcome to another Paddocks tutorial. This particular tutorial arises from a discussion that I had with Shannon Lee Moore-Barnes of Port Elizabeth on the discussion forum. And the issue that I want to deal with is when can sectional schemes debit owners' account? What are the restrictions and why do they exist? We'll touch on levies, cost recoveries, quasi-levies from future development right holders, interest on arrear amounts, other charges, basic principles, and special rules that authorize debits. Firstly, let's look at levies, general and special. Well, these fall into a special class. The Act and prescribed rules cater specifically for this type of charges. They're necessary to finance the scheme, and they are designed to be implemented in terms of a transparent process. They apply to all owners. Cost recoveries are something slightly different in that the holders of exclusive use rights and future development rights in respect of those areas are obliged to repay to the body corporate its costs relative to those areas. They're designed to cover the body corporate's costs, and this type of charge applies to an actual disbursement that might have to be proven, although in some cases monthly estimates are in fact collected. You'll see a picture of a couple moving in, and that reminds us that insofar as people hold future development rights, from the time that they in fact get official sanction to move in, from the time the occupation certificate is issued, they have 90 days in which to register the sectional plan of extension, which brings the unit into existence and causes a liability for actual levies. If they fail to do that within 90 days from the time that a certificate is issued, then they pay levies as if the sectional plan of extension were registered. There's no element of penalty to this or any associated costs, but basically the body corporate is again put in the same position it would have been had they done what they were supposed to do timeously. There is a provision for interest on arrear amounts. PMR 31.6 says the trustees are entitled to charge interest on arrear amounts at such rate as they may from time to time determine. And even if they don't determine a rate, the prescribed rate of interest act applies, and interest is payable at the predetermined rate, which I think is 15 or 15.5% at the moment, from the date of a written demand. What about legal costs? Well, in terms of PMR 31.5, an owner is liable for all legal costs incurred by the body corporate in three situations. Firstly, when they're suing for recovery of arrear levies. Secondly, in obtaining recovery of any other arrear amounts due and owing by such owner. Please concentrate on the due and owing. It isn't just what's claimed, it's what is actually due and owing without any question about it. Also, in enforcing the rules or the Act. What are the basic principles of owner liability? Well, it's fundamentally down to the laws of natural justice. The trustees or the managing agent can't assume that an amount or a liability for a particular debt is just settled and proceed to collect it without consent from the owner concerned or an adjudication of some time. In regard to the fundamental liability, is the person liable or not, the trustees can't just say you are liable. They have to bring a claim against that person before they can debit their levy account. And a claim is not collectible until there is legal certainty as to the amount. You may say that the reasonable cost of repairing common property was X. I may say I didn't cause the damage in the first place, so I'm not responsible for the person who did. And even if you prove that I did, I'm allowed and entitled to argue that the amount you spent to fix it wasn't reasonable. What happens when a scheme has special rules that authorize particular debits, ones that say, well, the trustees can just debit your account or whatever? Well, the real question is, can a scheme rule validly take away an owner's right to due process? And the answer is no. The requirement for due process is a rule of natural justice, and all schemes' rules must be reasonable. Therefore, no such rule could conceivably take away a person's right to a hearing, for example. The body corporate can't recover amounts from an owner without a fair process, confirming liability and that the amount is in fact reasonable. Thank you very much for watching this Paddocks Club tutorial, and I look forward to chatting to you further in the discussion forum.